Hello, and welcome to the Trans Tipping Point podcast, the podcast that is perhaps the most poorly produced podcast in the world, but which gives you the best content. I wanted to get on here and give you a brief update about an issue that I think is really important, and that is the arrest and prosecution of Don Lemon. Don Lemon is a nationally prominent journalist who worked for CNN for about 20 something years. He has his own show now. I think he kind of does it online. It's kind of independent journalism. He's a progressive. He's not like an extremist or like a radical or anything. He's pretty like mainstream Democrat, maybe a little left of the party at this point in the sense that he doesn't have to toe the corporate line anymore. But he's not out there like being crazy or anything. Now, he was in Minneapolis covering the ICE protests up there a couple weeks ago, and there happened to be this protest that he learned about that was going to take place. You see, there was this church in Minneapolis that was going to be that has I think it's an assistant pastor who happens to work for ICE, and these are like I assume Christians who feel that the message of the gospel clearly indicates that you should welcome the stranger, and we were strangers once, and this is I'm referencing the Gospel of Matthew. I believe it's Matthew 25. I should probably look that up, but anyway, there's a section of the Bible that says, I was hungry, you gave me food. For I was thirsty, you gave me water. For I was once a stranger, and you welcomed me. This is a allegory that Jesus is making to the Jewish people who were once strangers in the Old Testament, but he was commanding his flock to welcome the stranger, meaning immigrants, people who are not from the area. Okay, so that's the Gospel of Matthew commanding us to be welcoming of immigrants, and so these Christians had that viewpoint, and they wanted to protest these Christians that were going against that viewpoint. Fine, whatever. People can have different ideas, whatever. And so the idea for the protest was they would go into the church and do a disruptive sort of civil disobedience style protest. Now, Don Lemon learned that this was going to be happening, and he decided he would cover this event as a journalist. So he went there with his producer, and he filmed this protest as it broke out, and then he also interviewed people. He interviewed parishioners. He interviewed the assistant pastor, or no, the actual pastor, I believe, of this church. By the way, the church loosely affiliated with Project 2025 and white supremacists, but whatever. So he interviews that pastor, he interviews some parishioners, and he interviews some protesters. And then he's asked to leave, and he does. That's all that happened. Now, the right wing has been going absolutely crazy over this since it happened, because they view the perfect society as one like The Handmaid's Tale, where hardcore right-wing Christians get to control everything, and women are property, and minorities don't have a voice, and queer people don't exist, and all these sort of views. Now, they think that any attempt to disrupt that messaging or that normative worldview that they hold is some sort of like attack on their religion and their right to practice. Now, it's definitely an attack on their fucking racism, and it's definitely an attack on their fucking bigotry, and it's definitely an attack on the fucking fact that they think that the book that commands them to welcome the stranger actually compels them to be hostile towards immigrants. Absolutely, it's all of those things, but it's not an attack on their right to practice religion. They have that right, and frankly, anybody that gets in the way of that right, they can ask to leave, and then they can have arrested, and they can sue that, whatever. There's like a lot of remedies in law if you're a church and somebody comes and does civil disobedience. Now, history will judge whether that civil disobedience was righteous or not, but they are not being deprived of their rights. And specifically, and very importantly, having private citizens protest your church does not do anything to implicate the First Amendment freedom of religion clause. Because in order for a violation of the Constitution to occur, except the 13th Amendment, which bans slavery for everybody, all the other parts of the Constitution only apply as against the government. So when you have free speech, it says the government cannot do the thing that impedes your free speech. When you have the right to bear arms, you have the right to bear arms, even and the government can't tell you not to. When the Fourth Amendment says you have the right to be free from unreasonable searches and seizures, the government can't intrude upon your property. That's a violation of the Constitution. Now, if a private person does one of those things, you might have remedies against them too. You can certainly get somebody arrested for trespass or whatever, but it's not a Fourth Amendment violation. it's a different kind of violation. You can exercise those remedies. Now, these protesters were clearly not government agents, nor was Don Lemon. And so the first effort to try to prosecute Don Lemon happened shortly after this. The right wing was up in flames about this. They were going crazy about this. They thought that this was a clear act of pseudo-terrorism, basically. So they were like agitating on Twitter and other Nazi websites to encourage the Justice Department under Donald Trump and Pam Bondi to file charges against Don Lemon. Now, these people don't know the first thing about the fucking Constitution, so they didn't seem to realize that engaging in protest by private parties does not implicate their constitutional rights at all. But the DOJ, being the subservient little bitch that it is at this time in history to Donald Trump's Nazi regime, decided to go ahead and find a way. So the first effort that they did was they tried to prosecute under something called the FACE Act. The FACE Act was a federal law passed in 1994, signed by Bill Clinton. It was a well-meaning act that required a political compromise. You see, there was this problem in the 90s, and there's, certainly even today, but certainly in the 90s it was at a peak. Abortion clinics were being barricaded and blocked and firebombed, and patients were being assaulted and doctors were being killed. So the Congress passed a law that said protesters at abortion clinics they certainly have free speech rights. You can't take those away. They can stand there with their sign, across the street or whatever and protest all they want, but they cannot physically threaten or actually harm or obstruct the path of anybody trying to access that abortion clinic. Now, in order to get this to pass in the Senate or whatever, they had to get some Republicans to join over. 17 Republicans ended up joining, I think, 50-some Democrats to pass the law. And this ended up requiring compromise language to add the word houses of worship to the facilities that are protected. So basically, the Congress passed a law that said you can't use force to prohibit people from going to and from abortion clinics and churches. It gets a little bit more fuzzy than that if you really read the definition. There's a lot of words in this act. It says, for example, let me just pull it up, that it says whoever by force or threat of force or by physical obstruction intentionally injures, intimidates, or interferes with or attempts to do one of those things to any person who has been to or is going to or is to a health clinic, a reproductive health clinic, or a house of worship would be guilty of that crime. And then there's some different penalties depending on how serious it is. Now, the reality is that 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 language basically says injure, so you can't hurt somebody. Intimidate, which is defined in that law actually by definition in the law. Intimidate means to place another person in reasonable apprehension of bodily harm to him or herself or another. And then the other one is physical obstruction. Interfere with means that that's to restrict the person's freedom of movement. These are definitions that are in the statute. So basically, it's not good enough to do kind of a protest or, maybe a civil disobedience or something like that. You have to literally cause harm, threaten harm, or physically obstruct somebody with the intent to actually hurt them, with the intent to place them in immediate fear of being hurt, or with the intent to restrict their freedom of movement into and out of the clinic or house of worship. Now, this law was used to successfully prosecute abortion clinic terrorists, sarcastic terrorists in the country for years, and thankfully the number of attacks on abortion clinics went down. But for a while, the right wing has been upset about this because they think it's moral to murder and firebomb abortion clinics because they think, 10 or 12 fetal cells has the same value of life as, a 32-year-old poet or whatever. So they have wanted to get rid of this law for a while, but then Project 2025 comes along, right? This is this election plan for the 2024 election. And basically they decide that there's this kind of thing happening on the political right where they're brainstorming, how could we get rid of this law? And then some people are like, well, why don't we actually just kind of use it for our advantage and get rid of it for them, meaning liberals or progressives. So they propose a strategy where they will only prosecute people that get in the way of extreme right-wing white supremacist churches like this one in Minnesota. And they will not prosecute people who get in the way of abortion clinics, and that's been the case. Even under George W. Bush, they only did 2 prosecutions for abortion clinics, so this has been kind of in the air for a while. But the FACE Act requires one of those physical acts, harm, like violence, threat of violence, or physical obstruction to the facility. And it was very clear to the judge that reviewed the case that they initially tried to get Don Lemon on that wasn't going to pass muster, because Don Lemon didn't do anything like that. He absolutely did not obstruct anybody from going to or leaving the church. He didn't cause anybody harm, and he didn't put anybody in fear of being harmed. In fact, if you watch the video of him interviewing the pastor's the one using force against Don Lemon, not the other way around. It's very light, a small amount of force. He's kind of pushing him a little bit. So that was the FACE Act, and that failed. The magistrate that was going to sign the arrest warrant ended up not signing that because it was basically not, the evidence wasn't even to the level of probable cause, which I'll explain in just a second. Probable cause, I'll just explain it now. Probable cause means that in order to arrest somebody or do a search warrant, there has to be evidence presented to a neutral judge. This is language from the Fourth Amendment. The Fourth Amendment says the right of the people to be secure in their persons, houses, papers, and effects. Let me just double check that language. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and or the persons or things to be seized. That's the Fourth Amendment. Now that has this language, probable cause, right? So in order for the government to justify going into somebody's house or arresting somebody or searching a thing, persons, houses, papers, and effects, that includes houses, cars, wallets, whatever, they need probable cause, and they probably need a warrant. So the probable cause requirement has been defined to kind of interpret what that means as, quote, evidence that would convince probable cause means evidence that would convince a person of ordinary caution that a crime has been committed, and that, the person committed the crime that they're arresting, or that the place to be searched or the item to be seized is evidence of that crime. So it doesn't quite mean what we think of as probable, actually, because probable is a different standard in law. It's called preponderance of the evidence. Probable cause is just a little bit below that, maybe 30 or 40% likelihood. So you could almost think of it as quite plausible cause, or something like that. But it's kind of this murky standard that a lot of scholars think lands somewhere in the 30 or 40% range of likelihood. You don't have to prove that something's absolutely more likely than not to be a crime and that justifies the search or seizure. What you do have to do is you have to prove that there's pretty good evidence that that's likely the case and that some kind of crime is going to be investigated here, and you have to kind of particularly describe it and how you know that. And sometimes you're going to be wrong, and that's okay as long as you're acting in good faith, and as long as you have a pretty good amount of evidence to plausibly believe that that person or that search target is engaged in a crime. So in the case of arresting Don Lemon, the magistrate who was going to sign, was being asked by the Justice Department. So we're already at a really problematic place here. The prosecutorial arm of the government is already asking a judge, hey, we want to go arrest this guy for the FACE Act violation. Will you sign our warrant? Judge says, no way, Jose. This does not meet the evidentiary threshold of the FACE Act. So you cannot go arrest Don Lemon. There's not any evidence really that he did any of the things like physical harm, threats of harm, or physical destruction that are required. And so there's no real compelling evidence or there's certainly no basis to arrest this man. This case would be thrown out based on the evidence you presented in your request for this warrant. So the judge kicked it. So then for a week or two, the Trump administration spent time scrambling, looking for a way to go. They really want to get this guy. I should just take this moment as an aside to point out that Don Lemon happens to be a gay black man. Okay, I'm sure that's not related. They also arrested another black journalist from that same protest who was covering it locally, but I digress. She was a black woman. But anyway, so they couldn't get this particular judge in, I don't know if it was Minnesota or whatever, to sign that warrant while he was still there. So they went judge shopping and they found some. I think what they actually did, if I am reading the reports right, is they got a grand jury assembled somewhere. I think maybe in California. He was covering the Grammys in California. It might have been Minnesota, might have been California. I don't know where the grand jury was sitting, but what they did to get around their problems in the other cases, they found a grand jury. Grand juries are dumb. I mean, all a grand jury is, it's such a stupid process, but a grand jury is basically a group of like 24 people. It's usually about double a normal jury, who decide whether there's probable cause to investigate and arrest people based upon prosecutors telling them there's probable cause to investigate or arrest people. So if a prosecutor walks into a grand jury room and says, hey, this guy did this crime, and here's how I know, and you need to find probable cause, here's the standard probable cause, evidence that would convince ordinary people like you that a crime possibly occurred, most fucking idiot jurors on a grand jury are going to be like, yeah, fine, you go ahead and get your warrant, that's fine, maybe he'll get convicted, maybe he won't, but it's good enough, close enough. And the prosecution is under no obligation to present all of the evidence. They're under no obligation to have an advocate for the opposite viewpoint. They're under no obligation to give full due process to defendants subject to this process at all. So basically, a grand jury is like a rubber stamp jury. 99 out of 100 times, they're just going to do whatever the prosecutor says. Once in a while, you get a famous case where they don't indict somebody. Like, I think the sandwich thrower guy didn't get indicted in D.C. But in this case, what they found is that they could get a grand jury to indict Don Lemon on another charge. And that charge, and this is where the case gets really disgusting, is part of something called the Ku Klux Klan Act of 1871. This was a statute passed in 1871 to by the Reconstruction during Reconstruction to ensure that black folks in the South particularly were not subject to harassment, intimidation, death, violence, threat of death by folks like the Ku Klux Klan, who were trying to prevent black people from exercising their newly obtained rights after the Civil War. Because after the Civil War, we did the 13th, 14th, and 15th Amendments. The 13th prohibits slavery. The 14th grants due process, equal protection, and privileges and immunities. And the 15th is the right to vote based despite race. So when the this happened, the Ku Klux Klan and other right-wing racist entities in the South began retaliating against black people and trying to intimidate them out of exercising their rights, including the right to vote. So Congress passed a follow-up law called the Ku Klux Klan Act. This was an act designed to criminalize violence and other kinds of related threats against folks who are exercising their constitutional rights. Now, one of the statutes that was passed was this one, which I will show you. This is, let's see here. Well, actually, I'm just going to show you this one here. Okay, this is the Wikipedia article for the charge that Don Lemon is facing. And it's codified in 18 U.S.C. Section 241. And this was originally passed in the 1871 Ku Klux Klan Act, but it was subsequently modified a couple times. Basically, what this criminalizes is it says, if two or more persons conspire to injure, oppress, threaten, or intimidate any person in the free exercise or enjoyment of any right or privilege secured to him by the Constitution or laws of the United States, or because of his having so exercised the same, shall be blah, 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 fined and imprisoned and so forth. So basically it creates a felony for engaging in a conspiracy to take somebody's rights away, either under the Constitution or the federal statutory system that we have. Now, this code section is very similar to its companion code section, 18 U.S.C. 242. This is color of state law prosecution, and let me just find that. Do I have a Wikipedia on this one? No. This one's less well-known, perhaps, but this says that it's a crime for a person acting under color of state law to willfully deprive a person of a right or privilege protected by the Constitution or the laws of the United States. So it has pretty much identical language about acting willfully to deprive a person of any right or privilege protected by the Constitution or the laws of the United States. What it has in addition to Section 241 is it has this language about it doesn't have to be conspiracy. It can just be a person acting under color of any law. So that could be a state or federal. So basically what this says is that it's illegal for a federal or state official to deprive people of their constitutional or federal statutory rights, acting in their capacity as a state official. Now, the reason I bring that up is because the other act, Section 241, does not have the language acting under color of state law. It simply says conspiracy. If two or more persons conspire to injure, oppress, threaten, or intimidate any person in the free exercise or enjoyment of any right or privilege secured to him by the Constitution of the United States, or because of having so exercised the same. But I will tell you, and this you can look this up. In fact, I've got a really good source on this. This is the Journal of Federal Law and Practice. This is a law review article by, let's see here. I'm not sure who it's by, but let me just find Section 241. Basically, what this section is, okay, so prosecuting color of law civil rights violations. So this is basically a article discussing the history and relevance of charging people under this particular statute that Don Lemon finds himself charged under. And it says, the two primary statutes that criminalize the actions of governmental officials who abuse their authority to deprive their fellow citizens of their constitutional rights, conspiracy against rights, 241, and deprivation of rights under color of law, 242. Congress enacted these statutes under its authority to enforce equal protection of the 14th Amendment. So let me just pause there because this is important. The 14th Amendment prohibits the government from depriving any person of life, liberty, or due process, of life, liberty, or I think property, in any vested right that you would have or interest you would have, without due process. So it's a due process clause. It also has the equal protection clause, which says, nor shall any state deprive a person of the equal protection of the laws. So basically, when Congress enacts this this section here about the 14th Amendment being the basis for these laws, Congress is saying, no, we mean to apply this against government officials, not private citizens. Section 242 says that, for sure. It says under color of state law. But Section 241 was passed at the exact same time in the exact same act, right next to that language, and it cites the 14th Amendment as its basis. It's not just willy-nilly, trying to regulate commerce by criminalizing First Amendment violations that would otherwise not be First Amendment violations. It's literally saying we're doing 14th Amendment shit here. And the 14th Amendment can only be applied against state actors, not against private officials or private individuals. Now, let me just briefly talk about color of law. So this concept in both of these laws, Section 242 and Section 241, require the state to act under color of law. And there's a bunch of factors, including whether the official was on duty, wore a uniform, displayed a badge, identified himself, blah, blah, blah. Now, these are all cases dealing with both 241 and 242 prosecutions. So pretty much every case where this has come up, every court that's looked at this has said Section 242 requires the individual to be a government official and act under color of law, just like Section 242 says. In fact, in United States v. Price, one of the leading federal color of law prosecutions, the government brought a Section 241 and 242 charge against 18 white supremacists, 3 of whom worked as law enforcement officials and 15 who did not. The case involved the murder of 3 young civil rights advocates, blah, blah, blah. The district court initially dismissed the charges against the non-law enforcement defendants. The Supreme Court held that because those defendants had acted jointly with the law enforcement defendants to commit the murders, the private defendants could be charged as having acted under color of law. So what does that holding mean? That means that if you're going to do the conspiracy thing, literally the Supreme Court has said this law requires at least one of the conspirators to be a state actor. In this case, it was law enforcement that was conspiring with the private individuals. and in other cases it's been others, but it absolutely 100%. In fact, the district court went further. It said no private person could ever be held accountable. This is clearly about state actors. And the Supreme Court said, no, you can have private actors as long as they're conspiring specifically with state actors. And that's why this prosecution is so outrageous. Well, it's outrageous for a number of reasons, but that's why it's so outrageous. In this case, Section 241, one of the sort of implicit or, elements of this conspiracy is it not just another person, but at least one of whom has to be a state actor, a state official. Now, even if you were to assume that Don Lemon went to that church and conspired with those protesters to help them interfere with the worship of the people in the church, blah, 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 you would have to still prove that one of the individuals who conspired to do so was a state official. And again, going back to that article I was just citing to, the issue of whether they're a state actor isn't just as simple as they hold a government position. There's a bunch of factors, like whether the official was on duty, whether they wore a uniform, whether they displayed a badge, whether they identified themselves using an official title, whether they used government equipment, or took actions issued by and commands only by that an official could take or give. So government officials such as police officers will nearly always be found to be acting under color of law when they are on duty and in uniform, but it is possible for a person to act under color of law while off duty, just as it's possible for a person in a private capacity while on duty to act in a private capacity while on duty. So basically what that says is it says, even if somebody holds a government job somewhere, in order to be guilty of this crime, they have to be acting as that government official and using their government resources, their uniform, their badge, their tools, their authority to do the deprivation of rights. And in this case, not only is there not evidence of that, I think it's pretty unlikely that anybody was even a state official, but there's video of these people clearly dressed normally, not in any sort of state regalia, and they're clearly not acting under color of state law. So if it's required that one of the conspirators be acting under a color of state law, how in the world is a grand jury going to issue a indictment against Don Lemon? And the answer to that question is they probably didn't read the fucking case law. They probably just read in isolation this line. If two or more persons conspire to injure, oppress, threaten, or intimidate any person in the free exercise or enjoyment of any right secured by the Constitution. They probably just thought, okay, well, right secured by the Constitution, freedom of worship, that's fine. And were these people engaged in the free exercise of that right? Yes. Now, did two or more persons conspire to injure, oppress, threaten, or intimidate? I mean, maybe in the colloquial sense. I don't think in the legal sense, but you could argue that a disruptive protest could be a intimidating thing, maybe if it got rambunctious enough. I guess. So maybe you could investigate that or whatever. I'm not saying that's a good use of resources, but you can plausibly make that argument that the protesters were there and they had met together to form. Conspire just means you form the same goal and then you try to carry it out. So in this case, they could probably make out a case that maybe the protesters had conspired to intimidate church officials, or at least that's plausible. I don't think that's what happened, but that could be. But what you have to prove beyond that to get Don Lemon arrested is, one, he was in on the conspiracy, meaning he had the exact same intent as the people that wanted to cause the intimidation. So in other words, you ask whether his intent was, I want to go there and be a journalist, or two, I want to go there and help intimidate these worshipers. And if it was number one, it doesn't work. The second thing you have to prove, and the one thing that they clearly didn't read, is that this requires one of the conspirators to be acting under color of state law, which is clearly not the case. So they got the grand jury. This kind of goes around a judge. The grand jury found probable cause because they weren't told that one of the conspirators has to be a government official. So not only did the Trump administration violate the law by, trying to use the FACE Act improperly and by trying to use the Ku Klux Klan Act improperly, they actually lied to the grand jury about the elements of this crime. And I am very confident that this prosecution will be thrown out very quickly by a judge who will say, yeah, actually every single shred of case law on this requires there to be a co-conspirator who's a state official acting under color of state law. You have no evidence of that. Therefore, there's no probable cause to proceed with the prosecution. And that is just the beginning, because I want to point out two other things. First of all, I just want to say how insane it is that the white supremacist Nazi government of Donald Trump is using the Ku Klux Klan Act to prosecute Don Lemon, a black man, a gay black man. It's outrageous. I think they're doing it on purpose to, own the libs or whatever. But the second thing I want to point out is our country's track record of being a First Amendment country that protects the rights of journalists. It would be one thing if Congress passed a law saying journalists can only do X, Y, and Z. The Constitution is actually the superior law, and it says Congress shall make no law respecting religion, blah, 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 and then it goes on to say, or abridge the freedom of the press. So Congress shall not make a law abridging the freedom of the press. Now, that has been interpreted. There are some limitations to that general principle, but basically it means that if there's a law that rubs up against the ability of journalists to conduct journalism, that law is subject to constitutional scrutiny and will likely be struck down unless there's a compelling reason why it should be an exception. So when we have a federal law that's designed to prosecute KKK members for not letting black people vote in the South by killing them or threatening them, being used to prosecute a black journalist 140 years later, who was engaged in a constitutionally protected act of journalism, that is Orwellian as shit. That is a horrible standard and a horrible precedent to set. And I sincerely believe that this case will be thrown out very quickly. But I just wanted to point out how absurd it is. And I wanted to point out the legal analysis so you all understand that this is a completely illegitimate prosecution of Don Lemon, not only because he was engaged in protected First Amendment activity, even if the statute did purport to criminalize what he did, but more importantly because the statute doesn't even criminalize what he did. He didn't do anything remotely criminal. So I wanted to explain that. And then I also wanted to just say that this is part of a wider pattern in the Trump administration. This is part of a pattern of Donald Trump suing journalists that he doesn't like, suing pollsters who give him bad polling data. By the way, a lawsuit is ultimately a state action against the person you're suing. It's kind of a soft one, but ultimately, if you win a lawsuit, you're going to use the state to extract resources from the target of your lawsuit. So it is state action. So when the president, the most powerful member of the federal government, engages in a civil lawsuit against a media organization, he's engaged in state action to stop that media from engaging in First Amendment activity. So he's sued a bunch of people. He has he also the FBI raided a Washington Post journalist about a week and a half ago. They have arrested people for writing op-eds in support of Palestine. And this is let me just take 1 second on this. I know everybody knows that I'm a very staunch defender of Palestinian emancipation, but I think that it's important to note here that in the history of recorded warfare, no war has killed as many journalists as the Gaza genocide. The Israeli government has murdered without cause over 250. Let me just look up the latest on that. 274 journalists have been killed in Gaza since the genocide began. This is a number brought to you by the International Federation of Journalists. So, and if you look at the Wikipedia article about this, you can really get a good comparison. But basically, what I wanted to point out is that this is not a video about Gaza, but I just wanted to point out that when we start letting ourselves tolerate the mass murder of journalists in a war zone where a genocide is occurring, and we fund it, and half of the Democratic Party goes along with it, more than half, is it any wonder that the president here thinks he can just do the same thing and start using the power of the state to oppress journalists here? Of course, it's something that scholars call the imperial boomerang. This is basically the idea that our sins conducted abroad will come back to haunt us and boomerang back at us. So the funding of a genocide and persecution of journalists overseas has now come back, and it's now being used to undermine the free press here. And I bring up Palestine specifically because a couple people wrote op-eds or led protests, and they were arrested, and one was like about to be deported. The other one was, fortunately, the judge dismissed her case, but she was detained. Um, uh, let's see, op-ed punished. I'm trying to remember what her name was. Yeah, it's Ramea Ozturk is the name of the case. So this is the case of a student who wrote an op-ed just stating her opinion that she believed that Palestinians should be equal to everybody else in the region and that they should not be subject to murder and genocide. So anyway, she was arrested after she wrote that op-ed because the Trump administration disagreed with her. And so then eventually she was released, but now she's still subject to deportation proceedings in, I believe, Vermont. I'd have to read up on it. But the point is, and the other one is Mohammed Khalil, who was he's a protester at Columbia University, who's a green card holder. I mean, these are both permanent residents, so they're both here legally. They are both have what's called a permanent status, not a like a visiting status, but they're actually here with the intent to remain. And these folks are now being allegedly deported because of their political views, because they had the audacity to engage in activism, First Amendment protected activity, including in Ozturk's case, writing an op-ed, which is journalism. So this is a pattern, a deeply troubling pattern by the Trump administration to crack down on the First Amendment. They've also cracked down on free speech generally. Obviously, Minneapolis, I don't need to talk about, but you know, the idea that you have this secret police force out there in the streets, Trump troopers killing people for filming them, that's just the most absurd and obnoxious violation, not of the First Amendment in all of its senses: the right of press, the right of assembly, the right to petition the government for redress of grievances, the right of free speech. This is a war on the First Amendment being conducted by Donald Trump. And why is he conducting this war? Well, he's conducting this war on the First Amendment because in order for a fascist regime to seize power, it needs to be able to root out and diminish any dissent and opposition. This is what all fascists do. Mussolini did it. Franco did it. Fucking Pinochet did it. And of course, the OG fascist himself, Hitler, and not OG, I guess would be the granddaddy of fascism. I don't know. I'm trying to think of a phrase to say the most important, the most significant fascist in history, Adolf Hitler. But the point is that they all did it. They all cracked down on the free press. In fact, Hitler called the press the Judenpresse, which is German for the Jewish press, because he felt that any critical reporting about the Nazi Party was a Jewish conspiracy to undermine his power. So he eliminated the free press, just like he eliminated free and fair courts, just like he eliminated the right of people to assemble in the streets. And by the way, his moderate and even somewhat left, sort of center-left opponents in the Bundestag voted by majority to give him that power. So when we talk about collaborators to Nazism, we have to not shy away from the fact that sometimes center-left people have a historical track record of countenancing Nazi expansion of power abuses. But I digress. The point is that this administration is trying to do the exact same thing that every fascist regime in history has done, which is to go after journalists. And of course, I forgot to mention the Jimmy Kimmel thing and the Stephen Colbert thing. This is other uses of the state power to get critical voices outside of out of the sphere of reporting or public impact. And you may think Jimmy Kimmel is not a reporter, and that's true, but he was engaging in something that is protected, which is free speech, and arguably with an element of free press in there as well. And the Trump administration hates dissent, disagreement, or even pluralism in general, the idea that there can be different people living together. So that's why he's doing this. That's why he had Don Lemon arrested on false charges, and that's why he will try to push this. Now, is there any danger here other than the general pattern of him intimidating the press? I mean, in other words, could the courts go along with this? I don't think they will in this case because of the statutory argument I made earlier. The reality is that this case is so bogus. It's even more bogus than the James Comey case and the Fannie Willis case. This case is a case where there is no plausible way that he could be found guilty by any jury. And if he was, a judge would have to throw out the verdict anyway, because they simply don't have the elements of the crime present. Even if you don't like people protesting churches, which is fine, you have to admit that this is a outrageous overstep of federal law. It's like, it reminds me of when I was, a young lawyer, and we would go to these seminars where you'd hear about the latest and greatest cases. And of course, this is like in the era where they were prosecuting a lot more terrorism cases. So you'd hear these cases of like some guy who was mad at his wife, and he like put bleach on her bathroom floor or something weird like that. What didn't hurt anybody. It was just like maybe to annoy her, or maybe make the carpet turn colors or something. Anyway, that person would end up getting charged in federal court with like biological warfare. So again, like, can you like misuse the law and really like abuse how you treat people under the law? Yes, you can, but that usually gets cleaned up over time. In this case, it's so implausible that I really think all the courts that look at this are going to throw it out, and it will get affirmed on appeal. This is happening. He was arrested in California, but I think they're going to try to prosecute him in Minnesota, which is unfortunately in the conservative Eighth Circuit. But even the Eighth Circuit, I think, affirmed the previous dismissal of the charges against him, and have affirmed some other things that have come up in the Minnesota protests. So that are good, even for a conservative court. So, and I even think that our current fascist Supreme Court, I think it would be maybe 5-4 or 6-3, but I think they would probably also uphold the dismissal of the charges. In other words, they would not let this go forward. I could be wrong, though. Our Supreme Court is not trustworthy, and our systems are falling apart left and right, so be on the lookout. But I just wanted to bring this to everybody's attention because it's an important matter. It's a really important issue, and I just thought it might be helpful to have some in-depth legal analysis. So thank you for listening to the Trans Tipping Point podcast. This has been a quick update about Don Lemon. And be sure to tune in anytime I post videos. You can find them at the Trans Tipping Point on YouTube. Just search at the Trans Tipping Point, or you can email me at the transtippingpoint@gmail.com. Thank you for watching. We'll see you next time.